Okay, let's continue. Any questions? Okay, if no, then we continue with intention. Okay. So in case one party asserts the otherwise, okay, the owner's of proof is on him, which may be reliance on strong evidence subject to contract, comfort letter, or express intention of not legally bound. So for each of these grounds, right, we may rely on one of these grounds to claim that there's no intention of being legally bound, right? But for each of them, we have to rely on some precedents to illustrate this principle. So what is meant by strong evidence? As illustrated in the Australian woolen mills case. Now, if you can prove that you have strong evidence that you didn't have the intention to be legally bound, right? Then you have to prove it. You have to show it. So that is one precedent you can cite for supporting this principle, strong evidence. The next one is subject to contract. So in some contracts, when during the drafting and negotiation process, you may come across this statement or this phrase saying this contract is not yet a formal contract. It is subject to contract. So commonly stated in agreements between vendor and purchaser, for example, for sale of real estate, sale of a property. These agreements usually contain terms like price, dates for vacant possession, but what may remain to be fixed. So when you are going to buy a property, usually you will know the price. So it is 5 million, 6 million, or what, right? But the date for vacant possession, that means the seller is to make the flat vacant for you to possess. The date could be fixed to be agreed. It could be 2 months, 3 months, 4 months later. Okay. Then during the negotiation stage, usually that agreement is stated with a quotation subject to contract. That means it's not yet legally bound. Not yet legally bound. That means there is no intention yet to be legally bound. So incorporation of this phrase, subject to contract on such agreements, negates the intention. Okay, that means no intention of being legally bound yet, but allow the parties to have time to think over. You know, nowadays, when you are going to buy a flat, there's a cooling off period, right? So it allows time for the parties to think over it because that is a big transaction, big sum of money. Okay, as illustrated in this case, Attorney General case, 1987. And of course, if it is stated expressly in the agreement saying, oh, this is not legally bound, it is acceptable to the cost provided clear and ambiguous statements are used in such agreements. So to protect, right, to protect both sides. So if they have not yet 100% firmed about the transactions, right, during the negotiation stage, they may state that this is not yet legally bound, clearly, okay? So as illustrated in the Jones case, in that case, the parties will bound in honor only. In honor, bound in honor meaning no legal binding effect yet. Okay, so in that case, the statement is like not give rise to any legal relationship. Not give rise to any legal relationship meaning not legally bound yet. Okay, the binding in honor only. Okay, so binding in honor. Okay, the final element, capacity. People without adequate capacity to enter into contract, who are they? Innocent, people who are naive, okay, immature, Okay, say a child, 10 years old, right? Immature, mentally handicapped people, mentally not okay, right? Without a proper mind, healthy mind. So contracts are invalid if made with minors. Minors, the opposite of adults. Okay, not adults. Drunk persons like this guy. That means when they sign a contract, maybe they were drunk. Well, they were not aware what the contract is about, but signed it. Okay. And contracts may be made with individuals. So who can make contract? Individual persons can make contracts. Companies can also make contracts, of course, right? So in legal cases, but companies are not human. There must be some representatives. So companies are like artificial persons. We need to have representatives to sign. The persons, those persons, not everybody in the company has the capacity, but for example, the director, company officers, company secretaries, those senior people may have the authority to sign contracts on behalf of their companies. So there's a big ordinance, companies ordinance. This one is very big, chapter 32. Right? If you're interested, you can download this chapter and take a look. It's quite a long ordinance, right? Because there are a lot of provisions governing companies. So company ordinance requires companies to specify their objects, business. So different companies may have different businesses. That means different objects. Some may be, okay, providing cleaning service. Another company may be providing maintenance service. Okay. Any contracts made outside the scope of these objects, that is outside what is specified as their business, it is regarded as, again, this term is in italics. That means what? Latins, ultra vires, outside the company's capacity. Okay. So this doctrine of ultra vires was abolished. In the old days, it was there, but 1997, the Amendment Ordinance, Company Amendment Ordinance 1997, abolished this doctrine of ultra vires. So under this ordinance, companies can make any kinds of contract without being constrained by their business natures. Okay, so replace with this chapter 622. This is the old one, this is the new one. Okay, so that means what? In the old days, companies could only make contracts within the scope of the business or within the scope what is specified as their objects. But after that, companies is not bound to have that kind of contracts. Okay, then contract types and terms. Okay. What are the different types of contracts? What are the different terms of contracts? Well, we may classify contracts in different ways. For example, one way is to classify by looking at how the contract was formed. It could be completely oral. It doesn't need to always be in written form. Okay, it could be oral contract, oral agreement. Okay, but of course, not. Sometimes it could be difficult to prove. Okay, a better way, of course, is to be in written form, completely written. But it doesn't mean that oral contract is not a contract. An oral contract can still be a valid contract. Okay. Another way is written contract. The third way is partly oral and partly written contract. A mix of the two above. And then another way of classifying contracts is by defining them in the 5 different types, 5 types of contract. So let's take a quick look. The first type, contracts of record. Second, simple contracts. Third, contracts by deed. Number 4, unilateral contracts. In fact, you have heard about this last time, right? Unilateral contract. And the final one, collateral contracts. Okay, what are they? One by one. The first one, contracts of record. Judgments and recognitions enrolled in the record of the proceedings of a court of record. So then you may ask, what is recognizance? Recognizance, undertaking by an offender to forfeit a sum of money under certain conditions. Forfeit, that means agree not to take, forfeit. Okay. Says, for example, you have your annual leaves with your company overflown for 10 days already. That means within each year, you may have 20 days. You have taken 10 days for leaves, annual leaves, but you have 10 days left, right? But say if you do not take the remaining 10 days within 1 month or 2 months, then your leaves will be forfeited, right? So similarly, in this case here, forfeit a sum of money not to take, okay? Then that would be a contract agreement on that, and this will be recorded in the proceedings of a court. And law imply a debt, though the obligations arises from the entry on the record, not from the agreement between the parties. So it's these kind of transactions or contracts are usually about, in this case, the money. Okay. Another kind, more common, contracts without seal under common law require consideration. The opposite is contract with sealed, contract with seal, it could be a deed without consideration. So this is more common for most of the contracts, most common commercial contracts. So these are not contracts of record, that means not the previous type, contract of records, and not contracts under seal. Okay, so the third type is contracts under seal, for specialty contract, signed, sealed, and delivered, like the sale of properties, sale of a house, sale of a flat, sale of a piece of land. These are usually through contract under seal with deed. Examples in Hong Kong include real property transactions, government construction contracts, very big contracts, usually multi-billion contract. We may have these kind of contracts made by deed. Certain insurance contracts, again, for big sum of contracts usually, then we may have contracts by deed. But I would say for normal commercial contracts, most of them are here, including many of the FM contracts. Okay, here. Unilateral contracts. Still remember the case? Last time I showed you the video. Carlyle and Carbolic Smokeball, right? There was a case of an advertisement given by this company, Carbolic Smokeball. Mrs. Carlyle took that medicine, still got influenza, then sued, right? And that contract is a unilateral contract, one way. Unilateral, one way. Okay? To the whole world. That offer could be to the whole world. It's an advertisement. Remember that? Right? Collateral contracts, subsidiary agreements which stand alongside the main contract, is a kind of inducement to enter into the main contract. Could you imagine what it is about? Alongside, not actually the main contract. We have the main contract, which could be 1 million, 2 million. But alongside, there's another contract, which could be much smaller in sum, 10,000 only maybe, okay? To induce the other contract party to enter into the main contract, as illustrated in the City and Westminster Properties case. So, for example, okay, Say the maintenance service for this building for a year could be, okay, 1 million, okay, Hong Kong dollars. Okay. And then the cleaning service for this room for a year is 10,000. Okay. So the collateral contract could be the cleaning service for this room only 10,000 Hong Kong dollars. If the contractor was enter into this contract, then I would award the maintenance contract 1 million for the whole building to you. Understand? So that is a kind of inducement, trying to attract, okay, the contractor to join to sign the main contract. So this is what we call collateral, alongside, not actually the main contract. Negotiations. Is this common? It's very common before contract formation, right? Before a contract is formally formed, usually there are negotiations between the buyer and seller, the contractor and the employer. Okay. Often takes place between the parties before a contract is formed. Statements made in negotiations do not always mean they were in fact made or meant to be legally binding. So take the same example, 1 million for maintaining this building for a year. Okay. So the contractor may quote 1 million. The employer may say, oh, it's too expensive. 0.99 million. Okay. Then the contractor may say, oh, it can't be 0.99. Okay. Okay, 0.995 million. Okay. Then this kind of negotiation may go on several times. Not only about the price, maybe about the scope as well. Okay, the scope of work as well. Okay. But all these things may or may not, that's why do not always mean that they will in fact mean to be legally binding. Statements eventually form part of the contract are terms, contract terms. And for these contract terms finally incorporated into the contract, we can further divide them into two types: express terms and implied terms. Okay, so we have the express contract terms. We also have implied contract terms. So express meaning what? Clearly written, clearly stated in the contract. Contract clauses clearly stated. Okay, in maintaining this building, the contractor needs to clean the air filter once a month, for example. This is very clear, right? Implied term, the contract doesn't mention the tools used for cleaning the filter, but still the contractor needs to provide tools for cleaning the filter, right? So although the contract doesn't specify the tools to be used for cleaning the filter, it is implied that the contractor has to provide some tools for cleaning the filter. Understand? Okay, that's the difference. So express terms clearly stated could also be orally. Okay, orally mentioned. Terms for specifying things. The case I mentioned is to clean filter, but could also be like dimensions, quantity, quality of work to be done. Okay. And in some contracts, all the terms are in writing. And these terms are described as being confined within the four corners of the contract. Why? Because traditionally, we have contracts which are documents, right? A4 paper size maybe, right? In that documents, A4 papers, we have four corners. Right? It's kind of descriptions saying what is stated within this contract, within the four corners of this contract document, those are the terms. And that would confine the contract, the scope of the contract. Implied terms, I already mentioned an example, can be a term which has not been incorporated into the contract. As I said, not stated in the contract. Can even be one which has never been discussed. The example I quoted, providing the tools for cleaning filter, could be not mentioned anywhere in the contract. It is expected. Okay? It's a common practice. Expected, implied. Okay? Speedy commercial operations in Hong Kong, drafting contracts in haste is not uncommon. That means it could be common. Courts are willing to imply terms in contracts to represent the obvious, though unexpressed intention of the parties. So something not mentioned doesn't mean that it is not covered. The reasons for having this, I would say, flexibility or implied intention include the following. The previous conduct of the parties. Say there was a previous contract or there were multiple times of previous transactions of cleaning air filters. Every time the contractor comes to the site, the contractor will provide the tools. Right? Previous conduct. A custom or trade usage. Trade usage so is common in the trade, in the field, in practice. Whenever a contractor carries out filter cleaning, the contractor will provide the tools, even though that is not mentioned. This is a common practice, custom. As required by statute. Remember what is statute? I mentioned this. Last time I talked about 3 words, right? Statute, status, and statute. Remember that? Statute is one of the 3. Statute relates to the term statutory requirements. Statute, written law, legislation, ordinances, regulations. Okay? So what are required by the regulations, the ordinances? They are implied, even though they are not mentioned in the contract. But in practice, I'm quite sure that you have read some contracts before, and very often you'll find that the contract will also mention, okay, in providing this service, this cleaning, this maintenance, you have to comply with ordinance, blah, 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 chapter number, so and so, right? But here, even if it is not mentioned, as long as there is some sort of statutes governing that, it is implied. That is an implied term. The contractor needs to comply with the statutory requirements. Expected. Okay? And another reason is the need to give business efficacy. The pace of commercial operations in Hong Kong is so quick. So that's why the court usually allow, in order for speedy commercial operations, allow some terms to be implied into a contract. Okay? So based on which, what are the principles based on which some terms could be implied? For the term to be able to be implied, it needs to be reasonable and equitable. Okay? It could not be unreasonable. Okay? You could not expect a contractor to provide a very, very high cost of tools to do the maintenance service. You could only imply a term for requiring the contractor to provide ordinary, normal, common tools. Okay? Those are reasonable. Necessary to give business efficacy, as I said, as mentioned earlier. If we do not allow such terms to be implied, that would affect the effectiveness of the contract. That's why we will allow such terms to be implied, even though they are not stated. It's so obvious that it goes without saying. Expected. It's common everywhere. Everybody expects that. And if that is an implied term, if we really want to write it expressly, it can be done. Capable of clear expression. Say, the clause I mentioned, providing tools for cleaning filters. Although it is not mentioned, but if now we want to mention it, state it clearly, it can be stated clearly. Okay? Non-contradictory to any express terms. Same example, if in the contract it is mentioned that the contractor does not need to provide tools for cleaning filters. If it is stated that the contractor does not need to provide tools, then you could not imply the term saying the contractor needs to provide tools. Because what? That is contradictory to the express term. Understand? Okay. Now, these are some principles that needs to be complied with before such terms could be implied. Okay. Parallel evidence rule presumes a written contract embodies to complete agreements. Written contract like the contract documents, four corners. You may cite this case, Jacob's case. It forbids the admittance of extrinsic evidence. Extrinsic meaning what? Coming from outside, external. So the contract should be governed by the four corners of the contract documents. Something outside, coming outside from the contract, it is forbidden, forbids, not allowed. Okay. Confines the parties to the four corners of the contract, and this parallel evidence rule applies only when the terms are in writing and clear. Okay, so that is why it's so important to have the contract conditions, contract clauses clearly written. Strict applications of the rule may lead to injustice, therefore there are specific exceptions. But of course, well, there are often some exceptions, not 100% guarantee. There are some exceptions. Trade usage and trade custom. I mentioned this before, right? Here, custom trade usage, allowing contract terms to be implied. So this is a precedent illustrating this principle, reliance on trade usage and trade custom. Again, allow you 2 minutes to read the facts of this case, the Hutton and Warren case, and the decision held. Then I will explain the facts and the decisions to you. Finish reading. Trade usage and trade custom, the common practice in the field. The plaintiff in this case occupy and cultivate a farm under tenancy. There's an agreement, tenancy agreement between the plaintiff and the defendant. It's about cultivating a farm. He had managed the farm, but then he stopped the farm pursuant to a notice given to him by the defendant. The defendant gave notice to him to stop cultivating. The plaintiff P, okay, in short, I call it P, plaintiff Hutton, okay. P claimed that it was a local custom that a tenant was bound to farm in accordance with blah, 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 and entitled to a fair allowance for seed and labor. So in cultivating the farm, the plaintiff claimed that it is common, it is a local custom that the farmer would receive allowance for the seed and labor. Even though under the terms of written lease that made no provision for such allowance. So in that contract, in that tenancy agreement, it is not mentioned, no provision for such allowance, okay? But the plaintiff claimed that it is a common local custom, although it is not mentioned. So what was held? The court allowed extrinsic evidence, extrinsic coming outside from the contract of custom and usage. So this extrinsic custom and usage was not covered by the statement within the contract, not covered by the contract terms. But it has long been settled that in commercial transaction, that this is the kind of known usages have been established and prevailed. So in short, the court allowed this extrinsic evidence, which is custom and usage, to be admissible, to be implied. Although the contract doesn't specifically mention this kind of allowance. Okay? So this is an example of relying on trade usage and trade custom. Okay? And as a kind of extrinsic evidence. Usually forbidden, but sometimes allowed. Caution, but be careful. Relying on trade usage or custom is not always successful. Again, be careful of some exceptional cases. As illustrated in the Chen Li case, Chen Li and Aoki. So those working in the construction industry, maybe you have come across this company. It's quite a famous company in plumbing and drainage contracting work. And Aoki is a Japan-based company, construction company. Okay, so it's often main contractor, subcontractor, right, for in building construction work. So in that case, the plaintiff, Chen Li, was a subcontractor of the defendant, Aoki, the main contractor. Plaintiff claimed, although there was no provision allowing the defendant, that is Aoki, to retain a part of the interim payments, the defendant had done so. That means Aoki has retained part of the payment not given to Chen Li. You know, when constructing a building, usually, in this case, the money comes from the clients. The clients pay to the main contractor, Aoki, and then Aoki will pay the certain part to the subcontractor, Chen Li. But in this process, Aoki has retained part of the payment, not paying to Chen Li. Okay? The defendant, Aoki, argued that this is a custom or usage of the construction industry in Hong Kong, even though there was no retention clause in the contract. That means even though the contract doesn't mention that the contractor can retain certain sum of money, not paying to the subcontractor. So Aoki said that this is a common practice. This is a custom. Can it be done? It was held that the defense from the main contractor failed. Why? For a term to be implied into the contract, for a trade usage or custom, it must be capable of being formulated with sufficient precision. This is number one condition. In this case, that was not possible because various matters were not specified. What were not specified? Number one, the maximum percentage that could be retained is not set, was not specified. The retention period, the length of the retention period, not specified. Various things are not specified. Okay, so whether the fund was repayable in past and whether there was a clause allowing the retention fund to be held on trust for the paying risk, all these were not specified. Okay, so therefore, in order for a trade usage or custom to be effective, to be implied, they must be capable of being formulated with sufficient precision. If they are not precise enough, not clear, not specified, various matters, then it could not be relied upon, as in this case, retaining the payment. Okay, another important distinction between terms and mere representations. Remember, I mentioned negotiations. Before a contract is formally formed, during the negotiations, there could be statements made between the two parties. Okay, you want this price, I want you to reduce the price, give me a discount, right? So and so, right? Back and forth negotiations. Terms, statements which form the express terms of the contract, constitute promise as to the present truth of the statement. If such a promise is broken, this will involve a breach of contract. But if different from contract terms, some terms are not statements that are expressly incorporated into the contract. Some are just mere representations, statements not forming part of the contract, but help reduce the contract. What does it mean? There may be some statements back and forth between the two parties during the negotiation period, but not every statement would form part of the contract. Some are just representations. If, in case, some of these statements are found to be untrue, then that is misrepresentations, not true. So the distinction between a term and the representation is depending on the intention of the parties in making the statements during the negotiation. The court would try to decide whether this is really the intention of the two parties by applying an objective test, but again, it remains uneasy to do so in some cases. But here are some guidelines in determining whether there is an intention. I think I can jump a bit and then I'll go back to explain to you. This will help your understanding. As I said, diagrams are useful, especially when, say, you are from a science background, technical, engineering, surveying background. I think you would very much like reading diagrams than reading text. Say, during the negotiation process, that may be the start of the negotiation process, that is the end. There could be condition A mentioned by party A, but then in return, condition B may be proposed by party B. And throughout this long negotiation process, eventually, maybe only condition A is mentioned again. Condition B no longer mentioned at the end of the negotiation process. So the time matters. Likely to be a representation if the statement made at the beginning not repeated afterwards. This picture, condition B was mentioned at the beginning, but not mentioned anymore at the end. Then this condition B is likely to be just a representation. Okay. And it would probably be a term, a contract term, if the statement is made or repeated just before concluding the agreement. Condition A was mentioned at the beginning, is repeated just before the end of the negotiation. This condition, A, is probably a term, contract term. So what's the difference between contract term and representation? For a contract term, it is a promise. If it is broken, this would involve a breach of the contract. For representation, they just help to induce the formation of the contract. If they are broken, that may not lead to an entire breach of the contract. And in case they are untrue, they are misrepresentations. Untrue. Some statements, some conditions mentioned here, say if B, condition B is mentioned here, which is untrue. Okay, say condition B is I'm going to sell you a car. The car is in blue color. Okay, but in the end, during the transaction, the car is found to be in red color. Then this statement made saying the car is in blue color is a misrepresentation, which is not true. But the party relying on that statement, believing in it, believe that the car is in blue color, and then sign the contract. Then that is a misrepresentation. Okay? So another principle or guideline, we are talking about the guidelines in deciding whether that is a term or representation, right? We look at the relative importance of the statement. The higher importance, more likely it is a term. So how to determine whether it's important or not important? We should look at, scrutinize the negotiations themselves and the background against which negotiations were conducted. We have to look at the issues, negotiations, the backgrounds, the matters being negotiated to decide whether that clause, that statement is important or not important. Statement not included when contract reduced to writing. Anything that has been left out in the contract presumed to be a mere representation. As I said here, condition B was mentioned at the beginning, but it was left out when signing the contract here. So this is presumed to be mere representation rather than a contractual term. Knowledge and skill of the parties. A statement made by a party who possesses special knowledge or skill, more likely to be considered as a term of the contract. So the background of the party would also need to be taken into account, as illustrated in the Esso Petroleum case. This knowledge and skill of the parties matter. Okay, the final type here, contractual collateral contracts. Okay, I would explain this to you after the short break. Collateral contracts, okay? Let's take a break.